Thanks for watching this video, proudly brought to you by AN Immigration Services and Consulting. Please ensure that you watch this video at high resolution for best video quality. The information in this video is for general guidance on matters of interest only. It is not intended to be comprehensive, and they do not constitute and must not be relied on as immigration advice. Please seek specific immigration advice tailored to your circumstances from a registered migration agent. Please subscribe to our channel, like and share this video. Let us be part of your journey in Australia and support you throughout this journey.
Hi there. Does it matter what my immigration status is when I depart from Australia?
Hello. Yes, your immigration status at the time of departure from Australia does matter. Especially, if you depart Australia without a valid visa. It will affect you if you want to return to Australia again.
Does it mean that I cannot come to Australia?
Not at all. However, if you want to return to Australia, you may be subject to a 3-year ban. That is, you must wait for 3 years since the departure from Australia, which has triggered the 3-year ban before you can lodge another visa application.
How is the 3-year ban triggered?
The 3-year ban is imposed on you if you departed from Australia as an unlawful non-citizen or as the holder of a bridging C, D or E visa. For all non-citizens of Australia, they need a valid visa to come and remain in Australia. If you hold a valid visa while you are in Australia, you are a lawful non-citizen. However, if you do not hold a valid visa, you are an unlawful non-citizen.
Are 3 any exceptions?
Yes, the 3-year ban won't apply to you even if you depart Australia without a valid visa, as long as if you left Australia within 28 days after you ceased to hold a substantive visa. A substantive visa is a visa other than a bridging visa, a criminal justice visa or an enforcement visa.
Does it mean that holding a bridging visa at the time of departure will trigger the 3-year ban?
As I said earlier, only if you hold a bridging C, D or E visa at the time of departure. However, there are 4 exceptions. If you come under one of the 3 exceptions, the 3-year ban will not apply to you. The first exception is that while holding a bridging visa at the time of departure, you still left Australia within 28 days after you ceased to hold a substantive visa. The second exception is that the bridging visa you used for departing Australia was granted within 28 days after you ceased to hold a substantive visa. The third exception is that the bridging visa was granted while you held another bridging visa that was granted while you held a substantive visa. The fourth exception is that the another bridging visa was granted within 28 days after you ceased to hold a substantive visa.
What can I do if I do need to return to Australia within 3 years after my departure from Australia, which has triggered the 3-year ban?
In this case, you have to convince the department that the grant of the visa within 3 years after your departure from Australia, which has triggered the 3-year ban, is justified by compelling circumstances that affect the interests of Australia. This is a high threshold to reach. Ordinary visa applicants may not be able to satisfy the department on this ground easily. However, if the grant of the visa is justified by compassionate or compelling circumstances that affect the interests of an Australian citizen, an Australian permanent resident or an eligible New Zealand citizen, the department can still grant you a visa. Compelling and compassionate are not defined in migration legislation and should be given their normal dictionary meaning. There is no checklist of what is considered compelling or compassionate. It depends on your individual circumstances. Please note that it does not matter how the refusal of the visa application will adversely affect you. Your personal interest is not a consideration by the department. It is the interest of an Australian citizen, an Australian permanent resident or an eligible New Zealand citizen that counts. For example, if you have a family member who is an Australian citizen and has become seriously ill, and you want to visit him or her, the department may still grant you a visa on this ground.
I wish I had recorded our conversation so that I can share this information with my friends who are thinking of coming to Australia. I also have friends who will finish their working holiday in Australia next month and will return to their home countries.
No worries. I have a flowchart showing how PIC 4014 is enlivened and whether the exclusion period can be waived. The red lines in the flowchart are answers no to the question in a decision step. Please commence from start at the top. Answer the question in each decision step. Follow the direction of the arrows. I hope you will find this information useful.
Yes, thank you for all the support you have given me. The flowchart is very easy to understand as I can see visually how public interest criterion for 014 will be enlivened and how the 3-year ban can be avoided. I love Australia so much and I really look forward to coming and even working in Australia.
If I have been of assistance to you, you can subscribe to our channel. You can see a YouTube icon on the right-hand side at the bottom of this video. Please click and subscribe to our channel.
Of course, not a problem. I really appreciate your help.
Thank you, as many hours of work have been spent on depicting the Public Interest Criterion 4014 in a format that you can follow and understand easily and visually. With more subscribers on our channel, we can provide more content to support other viewers.